Greetings, my name is Walter Wilson. I'm a federal tax lawyer. I deal in federal estate tax and federal income tax. This affects everybody who is watching this video today. We have some law changes, and I always try to be proactive when a law change is clearly coming so that we can prepare for it. I want you to remember some things about federal estate tax. First, it's a voluntary tax. You, through your planning, determine whether it's going to be paid or not, how much is going to be paid, and when it's going to be paid. So you can actually control from the grave with proper planning. 2, the tax really isn't due until the second death, and everybody assumes that one of you, if you're married, are going to live to your expected mortality or longevity. That means when the federal government thinks you're going to die. So one of you is probably going to live, so they give you a deferral of the tax until the second death. Number 3, you will never pay it. That burden will flow to the next generation, whoever they are. Normally it's kids. And 4th, you're old and cold. Now what I mean by old and cold is if you were to give me your estate planning documents, wills, trusts, what have you, I would venture to say that they are old, meaning they were done 10, 12 years ago. And then you put them in a safety deposit box and you haven't gone back to look at them. They haven't been updated. When I mean cold, is just that. They were designed to do something, but maybe you've outgrown it now. Maybe it's not appropriate. People named in it are no longer with you or with us. And so they're old and cold. Now, we need to do 4 things. Imagine that we're standing on a train track, and in front of us is this train tunnel. And we can see some lights, a light, if you want, coming towards us. And that's the train. And that's the tax train. And we know it's going to pull into the station. We know when it's going to pull into the station, but there may be it may accelerate and get here sooner. So we got to be ready for it. So I want you to remember some dates. 2025, 2023, 2022, and something you have to do at the first death. 4 things. All right, now, what am I talking about? The tax is entirely voluntary. You choose how much is going to be paid, when it's going to be paid, and who's going to pay it. The tax is due 9 months after the second death of you and your spouse. So you got to plan. It's not automatic. You got to plan for that, because that gives you a lot of time. If you're in your 60s or 70s, it's going to be 20 or 30 years. So you look at this, not what it is today. You look at it, what it's going to be at the expected date of death of the second of the marriage, if you're married. Could be 20 or 30 years. Number 2, you need to create a current personal financial statement. So you need to get a current personal financial statement together, and you need to do one thing to it. That is, a current personal financial statement is assets less liabilities is net worth. But if you own any life insurance and you can change the beneficiary under that policy, the death benefit has to be added to the net worth. Big deal. 3rd, you got to look at these dates. On December 31st of 2025, the federal exemption equivalent is going to drop from its current amount of $12,400,000 per taxpayer to $6 million. It's going to sunset. Now, we know that's when we know this train is going to pull into the station. But we have something outside that another train might get in front of it and pull in sooner. And sooner could be January 1st of 2023. And in some cases, it may actually go back to April of 2021. But we know that one train's coming in 2025, but another train might be coming to us on January 1st of 2023. So the reason we do a current personal financial statement and we have to ask, have you made any gifts? We need to figure out what is the current unused exemption amount that you've got. And you got to use it before January 1st of 2023. You got to use it. You got to make gifts of minority interests in something. Investments, what have you. It doesn't have to be cash. It could be a carried interest in deals. Who knows what it is. But you got to use them. And you got to use them by January 1 of 2023. We have to file a gift tax return with the federal government. We have to get an appraisal. But we got to do something or they're lost. They're going to be lost. So if you lose $6 million per taxpayer, that's $12 million total. Let's say you lose that. You've used some of it. We lose that. But it could be as much as $24 million. The only way we preserve it is to do what I just told you. Now, giving it away means we can also get it back. And nobody seems to talk about this. But if you'll make gifts to a trust for the kids or the grandkids, preferably the kids, we can get it back through something called valuation discounts. So you give away the unused portion of the federal exemption equivalents, we get it back by taking valuation discounts. So it's a wash, but it's a wonderful wash for them. The third thing we have to do is, what if we got stuff left over between the exemption equivalents that we save and the valuation discounts, which we get? They're a gift from the United States government. Well, there are ways to avoid tax on the rest of it. The whole idea of federal estate planning is pay the least amount to transfer the estate to the next generation. And I want that to be zero. Zero federal estate tax. And you can do that today. I said that you have to remember 706. Remember this. Put this in your safety deposit box with your documents. And that is, everybody is under the impression that the unused exemption equivalents, if we save them, are passed automatically from spouse to spouse at the first death. They are not. They're not. The surviving spouse has got to file a federal estate tax return within 9 months after the death of the spouse, the deceased spouse. And it passes the unused exemption equivalents on to the next generation, meaning her, the survivor. If you do that, it's called portability. And you got to put a piece of paper in your safety deposit box with your documents. Don't forget to move the unused federal exemption equivalents to the surviving spouse by filing a federal gift tax return. So 4 things. The law is going to change. One law is 3 years away if you're watching this in 2022. It is going to change possibly earlier to January 1 of 23. You got to use them. You got to take valuation discounts, which could eliminate federal estate tax for 10, 15 years. But if there is still a federal estate tax, there are 7 different techniques that we can recommend to you that will eliminate the estate tax of the kids. But that brings us to the kids. And that is mom and dad and mom, you got to bring them into the process. You got to bring them into the process so they understand what happens to the legacy when it gets to them. Because while we've eliminated federal estate tax at your level, now it passes to them. And the time, if your kids are 35, 38, 40, or whatever they are, it's an ideal time to take care of them. We have a situation in community property states where the kids inherit $3, $4, $5 million, whether from insurance or assets or what have you. They pay the estate tax unless they know us. And then they have the net. And kids get married. And kids get divorced. And it got to be brought into the process because you got to avoid a divorce trying to claim at least half in a community property state of the legacy that the kids get and you've worked so hard to build. So I hope that we can talk to you I hope that if we don't talk to you, at least you'll talk to your advisor and that you will take advantage of what I've just given you. Thank you for your time.